and the appeal in the matter of Moorwand Ltd and Hamblin and others.
Yes, Mr. Salter, Miss Hill-Smith, good morning.
Good morning. May it please the court, I appear with my learned friend Ms. Alexia Knight for the appellant Moorwand Ltd, who was the first defendant to the claim. The learned friend Mr. Alexander Hill-Smith appears for Mr. and Mrs. Hamblin, the first and second respondents. They are the claimants in this derivative action, but they act on behalf of the third respondent, R&D Global Ltd, which is an administration and has taken no independent part in these proceedings. This is Moorwand's appeal, by permission of Lord Justice Lewison, granted on 4th November 2025, from the order made by Mr. Justice Marcus Smith on the 4th of April 2025, allowing Mr. and Mrs. Hamlin's appeal from the order dated 23rd April 2024 of His Honour Judge Rayside, King's Counsel, and from the order made by Mr. Justice Smith dated 9th June 2025, which dealt with consequential matters including interest, and there is a specific ground of appeal in relation to finding of interest. May I begin with a brief outline?
Before you do, would you just give us a prospectus for the course of the hearing? What have you intended between you?
I've indicated to the learned friend that I'm probably good for most of today, probably halfway into the afternoon, to allow an equivalent time for my learned friend, and then a little reply from me if necessary.
Good. Well, if that's satisfactory to you both.
Your Lordship, yes. There is an uncontested application that I should just mention as a matter of housekeeping.
By all means.
Your Lordship, the supplemental bundle that is before you does not contain the entirety of the documents that were before.
So is this the unagreed supplementary bundle that we have, and is it now everybody's happy that we should include that amongst our papers?
I'm not going to make a fuss about it.
All right, good. Well, we'll see how often we go there. Good. So, right, we can now get on with the substance. Thank you.
Not at all. First of all, just a little outline. I'm going to come back to the facts in a little more detail in a moment. But the brief outline is this. In 2017, the claimants, Mr. and Mrs. Hamblin, were tricked by a fraudster into parting with about £300,000 of their pension savings to invest in what was described to them as an automated trading scheme, promising what were, objectively at least, impossibly profitable returns. £160,000 of that money, if I say a total of about 300,000, was paid to Moorwand, which is an electronic money institution, and was credited to the electronic wallet maintained by Moorwand for R&D. When Mr. and Mrs. Hamblin discovered the fraud, they took steps to discover what had become of their money and to try to recover it. Unfortunately, as is so often the case, the fraudster or fraudsters had long since faded away, folded their tents and got off into the night, and R&D, which had received the money, was insolvent and had been struck off for failure to file its annual return. Who then could they sue to try to get their money back? Well, the fraud perpetrated on Mr. and Mrs. Hamblin was what is known as an authorised push payment fraud. Having properly authorised the relevant payment, they had no claim against their own paying bank, NatWest, for not having prevented them from making it. As the Supreme Court reaffirmed in 2023 in the leading case of Philip against Barclays Bank, a bank owes no duty to its customer to police that customer's withdrawals to prevent them from doing something foolish with their money. Authorised push payment frauds were and still are a social problem. But in Philip, the Supreme Court also reaffirmed that it was no part of the court's task to formulate a reimbursement policy to deal with that problem. I interpose to mention that after the events with which this case is concerned, a regulatory compensation scheme has indeed been introduced by the Payment Services Regulator in late 2024. Under certain fairly stringent conditions, the paying and receiving bank will share the loss caused by such a fraud up to a maximum of £85,000.
Do we have those regulations in the authorities bundle?
No, my lord, we do not.
I'd like
They're not actually regulations. They are specific directions by the Payment Services Regulator. If I remember rightly, it's specific directions 20 and 21. But we can get them overnight if your lordship would like. It's not a problem. However, that scheme is limited to payments through the faster payment scheme and through CHAPS, and does not extend to international payments. The scheme is not retrospective and so could not help Mr. and Mrs. Hamblin. In any event, the payment of £160,000 which Mr. and Mrs. Hamblin made was made to Moorwand's account maintained with a Danish bank, and therefore was an international payment and wouldn't be within the scope of the scheme. Mr. and Mrs. Hamblin say that the money paid into R&D's electronic wallet with Moorwand was impressed with a trust in their favour, inter alia because they say it had been obtained from them by fraud. However, they have not made any claim against Moorwand in equity and could not do so, since Moorwand knew nothing of the fraud and the money had been paid out of the electronic wallet long before any claim of fraud was made.
You say they say it was impressed to a trust. That was what His Honour Judge Rayside found, wasn't it?
Indeed.
And that's not
That's
in
not
dispute.
It's not appealed, Lord. No.
No. So before us, it has been established that it was impressed with it. It's not just what they say. It is not now disputed.
Your Lordship is quite right to correct me. I'm sorry, that was merely a loose expression. What we do, if necessary, dispute are some of the grounds on which they say it was impressed with the trust.
My understanding is it's now put on the basis of what's called a Halley trust, which is that if your entire purpose is to commit a fraud, a constructive trust attaches straight away. Is that right?
That's indeed, my lord, and that is going to be an aspect of our submissions, as it were.
Yes.
But we're not disputing that as against the fraudster, there was a trust of the money on the Westdeutscher basis that it had been obtained by fraud. But the Halley basis is slightly more controversial, if I can say that.
Well, yes, I can see that, but yes.
But your Lordship is quite right, and I'll pass on from there. The point I was making was they have no claim against us in equity, either for knowing assistance or for dishonest receipt, or for knowing receipt, rather.
Both of those require dishonesty, as it's now understood. Is that right?
Absolutely. Nor could they have any claim against Moorwand in tort, since Moorwand had not undertaken any responsibility to them and owed them no duty of care to prevent such a purely economic loss. That principle was reaffirmed in 2022 by the Privy Council in the case of JPSC4 against the Royal Bank of Scotland International. In any event, we say that such a claim would have been very significantly reduced by reason of Mr. and Mrs. Hamblin's own considerable contributory negligence. What remedy, then, remained for them? Well, they decided, no doubt on advice, that the way forward was to restore RND to the register, it having been, as I said, struck off, and on behalf of RND, to bring a derivative action against Moorwand, alleging breach by Moorwand of the Quince-care duty, which, on behalf of RND, they claimed that Moorwand owed to RND as its customer. His Honour Judge Rayside dismissed that claim on 23rd April 2024 after a 2-day trial, but Mr. Justice Marcus Smith, on the 4th of April 2025, allowed Mr. and Mrs. Hamlin's appeal, holding that His Honour Judge Rayside's decision was vitiated by, amongst other matters, what Mr. Justice Smith held was his error of law in equating the sole director and shareholder of RND with the company. We submit that on any showing this is a curious claim. Although Mr. and Mrs. Hamblin are the nominal claimants, they bring this claim on behalf of RND, and it is RND's rights, not their own, which they seek to enforce. Yet, Mr. and Mrs. Hamblin themselves assert, in their amended particulars of claim, that RND existed only for the purposes of fraud, but otherwise did not trade or conduct any form of business activity. I will, at a later point when I come to deal with the pleadings, invite the court's attention to the amended particulars of claim. But can I now invite the court to take out the supplementary bundle, not the unagreed supplementary bundle, but the original supplementary bundle, and turn behind tab 1, page 6. This is the reply, and page 6 at the top, paragraph 11, gives a bit of a flavour of how the case was put in front of His Honour Judge Rayside and what the basis of the claim was. It says, as the court will see, paragraph 16.4.2 of the amended defence is denied. That's the denial of the trust, of the constructive trust. Fraudsters were in control of RND. There were no legitimate directors of RND, and the fraudster or fraudsters were at all material times shadow directors of RND, purporting to act on behalf of RND. I apprehend that what's meant there is de facto directors rather than shadow directors, but the point is made that the fraudsters were acting on behalf of RND. The knowledge of the fraudsters is to be attributed to RND for the purposes of giving rise to a trust in favour of the claimants in respect of the monies paid into the account. So they are, at least for one purpose, they're directly attributing the knowledge of the fraudsters to the company, but effectively saying that there were, it was under the control of the fraudsters and there were no legitimate directors. That actually slightly contradicts some matters in the amended particulars of claim, which I shall come in due course. This approach of the claimants at first instance is reflected in several places in the judgment of His Honour Judge Rayside. And can I invite the court's attention to that, which is in the core bundle behind tab 17. If I can invite the court to start at page 201. Paragraph 46 of the judgment, His Honour Judge Rayside says, in these proceedings Mr. and Mrs. Hamblin wish to bring a novel derivative action and therefore step into the shoes of RND as their trustee. They have not sought, as is usual, to bring a tracing action or sought all the normal remedies available in equity and unjust enrichment typical of these claims, but instead novelly wish in effect to become RND, which is a fraudulent, valueless special purpose vehicle set up for the sole purpose of receiving monies and paying them into the Bitcoin market with a few other transactions, including a single standalone watch payment. And the learned judge returned to this theme over the page 203 in paragraph 58, where he says, equally it is perfectly clear, looking at the contemporaneous documents in respect of RND, that it is, in effect, in fact, nothing more than a special purpose vehicle set up by fraudsters, effectively with no shareholders, no assets, no website, no trading history, no accounts, indeed absolutely nothing that a normal company would have, and that is how they stand so far as all the world reads their documents available at this trial. Paragraph 59, he says, when Mr. and Mrs. Hamblin bring their derivative action, they step into the shoes of RND, and therefore they become an organisation which has all the makings of RND as set out above. They do not, when they bring a derivative action, proceed in their own right as individuals who've been the subject of a fraud. My lords, there is no pleaded allegation that anyone whose knowledge is to be attributed to Moorwand actually knew of the fraud. And the business account agreement, which was the contract between Moorwand and RND, contained a standard warranty, which I will show the court in a moment, that RND would conduct its business involving its account with Moorwand in a lawful manner.
Sorry, I was just still looking at the page that you last took us to,
I'm sorry, my lord, yes.
which was page
203, I think.
203, and reading up on the earlier on in the page at 57. Part of the same treatment of R&D, and in this case the relationship between R&D and the individual whose name was borrowed.
Yes.
He says at the end of that, they're effectively one and the same fraudulent sham. What is the fraudulent sham that is there being described?
Well,
I mean, is it if one looked at it and said he's saying that this is a sham company?
he's saying it's a sham company. The whole thing was pleaded, the Halley Trust basis, which Lord Justice Nugee referred to, depends on showing that the SEX investment scheme, CEX investment scheme, was a sham, that the purported contract actually had no basis, that the invoices that were sent were shams.
Yeah.
And the company, he's saying, is part of that same sham. This whole thing is simply a fraud.
Yes, well, I'm just for the moment staying with the present case, I mean, because a lot of the discussion in this appeal is about the distinction between individuals and companies. But is the judge saying, I've no opinion as to whether it matters or not in legal terms, but is he saying that this was in fact a sham company?
Well, Lord, that's how I read, how we on our side read that particular passage.
Whatever that means.
Well, exactly whatever that means.
But indeed, my Lord, that's what I'm going to explore when I come to those parts of my submission.
Well, I mean, it just colloquially, as it were, it would be difficult to imagine a company that was shammer than a company of that kind.
Indeed.
I say nothing as to what the consequences of such a conclusion might be, but one's use in, for example, in tax consequences, to there being a difference between ambitious tax planning and a sham. And a sham is a very distinct and guarded conclusion to reach. But here the judge appears to be saying, in the passages that you've taken us to, that this may have been a company, but effectively it was a sham.
Lord, indeed. I'm going, if I may, to come to that when I come to who
Yes.
were the directors of it, because it involves a consideration, amongst other things, of the provisions of the Companies Act Section 15.4 and matters like that. As your Lordship anticipates, this is not, unfortunately, a simple way of unpicking it.
No.
But the standing back from the law and simply looking at the facts, as it were, the learned judge found, and we say this was the reality, that the whole thing was a fraudulent scheme. There was no intention to create any business. There was no intention to create any legitimate company for any legitimate purposes. There was a deceit perpetrated not merely on Mr. and Mrs. Hamblin, but also, we say, on Moorwand. We too are victims of this sham fraud. As I say, there was a standard warranty in our terms which said that Moorwand would conduct.
I just want to ask you about the reliance at this stage on those terms of the Moorwand standard trading terms. It doesn't seem to have been an issue that surfaced before. Had it surfaced, as they are standard terms, it might have faced the same UCTA challenge that Clause 16 faced, albeit unsuccessfully. On what basis do you say you get to deploy those terms now on this appeal?
Well, two things, my Lord. First of all, they are plainly pleaded, the terms, and they are pleaded in the section in which it is said that we failed to perform, and they are there. Secondly, the terms themselves plead reliance. It's a contractual estoppel. The terms themselves say, you contract that we rely on this, and that is in our pleadings.
But was any argument, and I think it's an occasion for realism, deployed before His Honour Judge Rayside, either that there was contractual estoppel, or that there was breach of warranties of authority, such like, so as to give rise to a defence of security of action.
My lord, neither are pleaded. Neither are pleaded, and Malone Jr., who appeared below, I did not, as I recollect, deploy those arguments in front of His Honour Judge Rayside.
I mean, frankly, whether they would be effectively change the seed, I think, is an interesting question. But I think that for the moment, the more immediate question is this a point that you're able to raise now?
Well, Lord, it's the facts are pleaded. And when I come to deal with the warranties, I have a section in my submissions in which I am going to deal with those. I shall point out that although we've not drawn the legal conclusion from them, we have pleaded the facts, the existence of the terms, and the provisions in the terms which say that contractually you've relied on them. And therefore we say that is a fact which we are able to deploy, not merely individually in the sense of giving rise to a separate defence, but also as part of the overall facts of the case and to do with the extent of the Queen's care duty.
You said you were going to come back to the whole question of the corporate existence, what this company was. Is it any part of your case that it's a sham in the sense that it didn't ever exist?
Not a point, my lord, I think I can take in view of 15.4.
Yes, I apprehended that wasn't your case, but once a company has been registered under the Companies Act, it is incorporated, even if the purpose of incorporating it is to perpetuate frauds on other people.
Indeed, my lord.
Yes.
That's been the law since the second decade of the 20th century.
Yes, that's what I thought. Thank you. So it's not a sham in that sense, because I mean sometimes when you say something is a sham, a contract, for example,
it doesn't exist.
It doesn't exist. That's not what the judge meant, and it's not part of anybody's case.
What it is that it is all part of the fraud, and the whole thing is the intention to deceive people into believing that, to deceive Mr. and Mrs. Moorwand into believing that they're going to get impossible levels of return on their money, and us to believe that actually they are a legitimate company.
Yeah. Thank you.
I was at the point in my opening in which I was saying that Moorwand itself was the unwitting victim of the fraud perpetrated by the person or persons who controlled R&D. And that was part of my submission that this was an extraordinary case, because here we have R&D, which the claimants say existed solely for the purpose of fraud, suing Moorwand for not having prevented that fraud from taking place. And we say that must on any show raise an eyebrow as to whether that is an appropriate function for the Quint's care duty. We say that the case therefore raises some fundamental issues, both as to whether the law ought to countenance this indirect way of circumventing the obstacles to claims by defrauded parties such as Mr. and Mrs. Hamblin, presented by the decisions in Phillip and JPSC, and the limitations on the statutory compensation scheme, and as to the extent and nature of the duties, if any, owed by a financial institution to a fraudulent vehicle such as R&D to prevent it from carrying out the very purpose for which it was set up. With that somewhat lengthy introduction, I'm now going to turn to our substantive submissions, and with the court's indulgence, I propose to make my submissions on this appeal under the following 5 headings. First, the background, so far as relevant. Second, who in law was the sole shareholder and director of R&D, which is grounds 2 and 3 of our grounds of appeal. Third, the extent of that sole shareholder and director's authority to act on behalf of R&D, and the consequences for this case. And under that heading, I propose to deal with the pleading issue, which is ground 4 of our grounds of appeal, and the representations and warranties, ground 5. Fourth, I propose to deal with the nature and extent of the quince care duty owed by Moorwand to R&D, and why we say, having regard to all the circumstances and to the practicalities, HSJ Rayside was right to form that there was no breach. And then finally, that's ground 6, sorry, and then finally interest, which is ground 7. I start, if I may, with the background. The court will, I know, have read the judgments and the skeleton arguments, so I shall spend only a very short time in setting the scene before turning to the main sections of my argument. Can I invite the court to take the core bundle and look at our skeleton argument behind tab 2 at page 27, as it may be helpful for the court to turn to the summary of the background in paragraphs 12 and 13 of our skeleton argument. I'm just going to amplify that a little as I go along and show the court some of the relevant documents. It's common ground. R&D was incorporated on the 22nd of February 2017. It's also common ground, as His Honour Judge Rayside found in paragraph 54 of his judgment, that the name given in the document sent to Companies House for the sole initial shareholder and director was a man called John Stanfield. Mr. Stanfield is a real person, but it is also common ground that the real Mr. Stanfield knew nothing whatsoever about all this until long after the event, when he was served with proceedings brought by Mr. and Mrs. Hamblin. Whoever it was, therefore, who set up R&D was not Mr. Stanfield, and we submit that the irresistible inference is that it was the fraudster, or one of the fraudsters, who later tricked Mr. and Mrs. Hamblin. And purely for convenience, I'm going to refer to that person or persons in my submissions simply as X. I can invite the court also to take out the supplementary bundle and turn behind tab 11. About a month later, R&D opened accounts with Moorwand. Moorwand is an electronic money institution which at that time was called UPay Card Limited. And using the name of Mr. Stanfield, X signed a business account agreement dated the 21st of March 2017. There's an extract from that agreement at tab 19 of the core bundle, but the full version to which I'm inviting the court's attention is in the supplementary bundle here. Can I invite the court just to look quickly at a couple of those provisions? I shall come back to it. Clauses 2 and 3 on page 108 are relevant. Clause 2 contains the first warranty. The client hereby represents and warrants to the company that all information provided by client and set forth in client information attachment is true, complete, and correct in all respects, and fully understands, agrees, and acknowledges that the company is expressly and directly relying on this representation and warranty in agreeing to enter into this agreement and to provide services hereunder. And then clause 3 incorporates the terms and conditions. I shall come to that. Just to give the court a flavour of matters that I shall come to later in my submissions when I come to deal with the practicalities under heading 4 of my submissions, can I invite the court's attention to the bottom of page 109, business account.
Just before you do that, you said Clause 3 incorporated terms and conditions, but it seems to incorporate the terms and conditions to the cards held by client rather than to this agreement generally?
Yes, they get a card.
But is the card of any... Does it play any part in this story?
Well, it's a word used, not a physical card, but it has a card. Can I invite your lordship's attention to go on to the business account details, because they explain this rather better than I can paraphrase it. If go to clause 5, upon paying the setup fees, company shall create a sponsor business account for client. In addition, company shall issue a card to client, and
Yes.
if one
There's a definition of card on page 107, which does seem to refer to a physical card.
indeed, there is a physical card, yes.
Does the physical card play any part in these transactions?
No.
No. So I don't at the moment. I'm not at the moment persuaded that clause 3 has anything to do with this case, but I may be wrong.
I shall come back to it, my lord. if
Yes,
I may.
was there any argument, in fairness to you, on this occasion, at any stage by the other side that the terms and conditions were not incorporated?
Not that I understand, no.
Okay.
Good. Can I come back to business account
Yes.
transfers? No doubt the letter can comment who was there when I wasn't. Anyway, client shall have the right to transfer funds from its business account to any company account via a business account transfer. Client may initiate a business account transfer through an application programming interface that company make available to the client. Client may initiate a business account transfer by sending an electronic file to the company in a format designated by company that sets forth the account to which it seeks to make a business account transfer and the amount it seeks to transfer. And then there's fees and things that says that you shan't are set out, and there's no limit. And then page 11, number 8, company shall use all commercially reasonable efforts to maintain its services in operation at all times, 24/7, 365 days of the year. And then over the page, paragraph 11, representations and warranties, with client's full understanding that company is expressly and directly relying upon the following representations and warranties in agreeing to enter into this agreement and provide services hereunder, which is my point about contractual estoppel. Client hereby makes the following representations and warranties to company. Client does, and at all times during the term of this agreement will, operate its business in strict compliance with all laws and regulations applicable to its business, the highest legal and ethical standards. And then C, use of the company's services. Client will not, during the term of this agreement, use any of company's product services in any manner or in furtherance of any activity which constitutes a violation of any law or regulation or which may cause the company to be subject to investigation, prosecution or legal action. Over the page 114, there's an indemnity and a limitation of liability. We accept, as Mr. Justice Smith held, that exclusion clause, while we say a very good answer to a claim in damages, which is how this claim was originally formulated, cannot be an answer to a claim for reconstitution of the account. Clause 21E applies English law, and on page 118 we see the signature of Mr. Stanfield. In fact, we say the signature of X using the name of Mr. Stanfield in the name of UK Global.
You said it. There was a provision governed by English law,
Sorry, Lord.
which I think is 21E. Is that right?
Yes.
It actually says the laws of the United Kingdom. Not a provision I've come across before. Is your submission that United Kingdom for these purposes means England, or what?
I'm afraid there's a substantial body of commercial court
Well,
authority
I thought
of the ultimately nationalistic kind that holds that the United Kingdom always means England in a context such as this. I'm conscious my Lord Justice Jackson won't find favour with that interpretation, but I think it's where we've ended up.
Thank you.
I'm grateful, my lord.
And your client is an English company, despite having a
Yes.
bank accounts in Denmark.
Absolutely.
Yes.
Absolutely. Can I invite the court's attention to the terms and conditions, which are behind tab 12. Because they say something about the way in which business operates. First of all, bottom of page 121, e-wallet means a virtual electronic purse provided to each account holder and may be denominated in different currencies at our sole discretion. Then, on page 123, in the middle of the page, under Roman 3, Companies, Accounts, Products and Services, A, Company Accounts. An account with us was opened for you at the time you purchased an account, when an account was purchased for you by another party, or when you were provided an account in any other manner. Your account consists of one or more e-wallets and any other company products purchased by or provided to you. You may access your account using a unique user ID, password that you were asked to set up at the time you purchased or were provided your account, and the designated authentication number from the key card that was provided to you. We will provide you with a sponsored personal account. Company e-wallet. When you signed up for an account or when you received an account from another party, we provided one or more e-wallets to you. To use your e-wallet, you must sign on to your account by entering your user ID and password and the designated authentication number from your key card. You can, 1, load funds.
Are you going to read the whole of this paragraph?
I was going to read to the bottom of that particular paragraph.
Or should we just read it to ourselves?
Lord, yes.
Yes.
The reason I was reading that out to the court was to give an indication. I will show some more of this when I come to the section 4 of my submissions. But this is a kind of straight-through processing. You make a transfer by putting in the relevant codes, and the computer does the rest. It's an electronic institution. And can I invite the court's attention on to the bottom of page 127, to the last 2 paragraphs on that page. And again, may I invite perhaps the court to read those to yourselves.
Yes.
These effectively say that RND will be responsible for all transactions made on the e-wallet using the codes provided. Doesn't matter who puts them in. You are responsible for the codes. And that's because, just like an ATM, the process happens automatically. You put the numbers in, the money goes. The monies are transferred. And we say that the UPay card contract was in the terms that it was because UPay card, effectively Moorwand, had to comply with the payment services regulations. And it is, we submit, important to keep in mind that Moorwand is an electronic money institution and not a bank. Electronic money institutions have a separate regulatory system from banks. They're regulated by the Financial Conduct Authority, not by the Prudential Regulation Authority, like a bank. And the regulations are not as stringent as they are for banks in order to increase competition and lower costs. The regime exists to give effect to the policy of the Payment Services Directive, which was implemented in the United Kingdom by the Payment Services Regulation, to promote speed of payments, particularly international payments within the European Union, and to lower the cost. And they've been very successful in achieving both. Electronic money institutions are not banks, they are payment service providers. And the regulations which govern them say that they're not intended to hold funds for prolonged periods or to perform the same roles as a bank. They cannot, for example, lend their customers money. They have to protect the money, unlike a bank which gets use of it, either by holding it in a segregated account with a bank or by insuring it. Segregated accounts are actually the standard, and Moorwand didn't hold the money itself, but with a bank, as is apparent from the evidence and the judgments. Electronic money institutions are also by statute barred from paying interest on money that they hold. This is to promote them, again, for being used as payment services and not as banks. And rather than try and take the court through the payment services regulations and the electronic money institution regulations, I'm going to invite the court's attention to the judgment of Ms. Claire Ambrose, sitting as the deputy judge, in a case involving Moorwand. I'm sorry this wasn't in the original authorities bundle, but I didn't realise it was there until this morning. I've provided my learned friend with a copy of it, and with my apologies for not giving it to him earlier.
Thank you.
And can I invite the court's attention within this judgment to the section beginning at paragraph 33 about EMIs and electronic money. And can I just invite the court to read through to the end of paragraph 41, just to get a flavour of what an electronic money institution is.
So, I'm sorry, the particular paragraphs we're to read.
33 to 41.
Thank you.
Right, well, you're showing us this to deal with the structural aspects of the system, not to do with the decision in this case.
No.
No. Okay.
Just because it is part of the background and relevant to the question of the extent, if any, of the Queen's Care duty.
And none of this was put before.
Well, it was certainly put that it was an electronic money institution, and that's a matter that is mentioned. It is also the payment services regulations were specifically dealt with in the judgment of His Honour Judge Rayside, who specifically finds that we complied with them and complied with our duties under them. Because there was a claim under the payment services regulations made against us, which was dismissed by His Honour Judge Rayside and also by His Honour Mr. Justice Smith. The learned friend is quite right that the learned friend this night did not show this particular authority to His Honour Judge Rayside, but the background to it, as it were, was indeed part of the case before the learned judge. both His Honour Judge Rayside and Mr. Justice Smith held that Moorwand had received a conforming instructions for the purposes of the Payment Services Regulation, and therefore were obligated to pay promptly. And it's part of our case that the level of scrutiny suggested by Mr. Justice Smith would be impossible for an electronic money institution performing under the terms of its contract. It would be inconsistent with the requirements of the Payment Services Regulations to execute instructions promptly once they're given electronically as specified in the contract. And we say it would undermine the payment system established by the Payment Services Regulations.
I just want to unpack this point. Is it said that the application of that regime here leaves no scope for any form of quince care duty to apply?
I'm going to say, when I get to that section of my authorities, that it leaves little scope. Okay. It doesn't, again, just to give a slight presage, the Philip decision says that quince care is an implied term of the contract between banker and customer. To be an implied term, it mustn't be inconsistent with the terms of the authority. And we say here the terms of the contract are those contained in the business account agreement and the terms and conditions. And the description which was supplied to customers, I'll show the court the documents at the appropriate point in my submissions, which provide, as it were, for straight-through processing, for the payment to be initiated electronically and to go out electronically. And if that is the contract, there isn't a great deal of scope for someone looking at the payment and saying, should this be made?
I'm just trying to...
What do I know about the general business of the company? It's not a bank. We are not back before the Second World War, when checks would come in and be physically looked at by a bank clerk to check that the signature conformed with the mandate, that the check was in date and that it was properly filled out and things like that. It's not how payments are made now. And therefore, we say that the scope of the quince care duty is similarly limited. And we say that that's what His Honour Judge Rayside found. He was entitled to find that on the basis of the contractual documents that he looked at and the evidence that he received. But I'll make that in more detail later.
At some point, I am, certainly speaking for myself, I'm keen to understand whether we are on the receipt of new points here. Existing argument now is not the occasion for it, but no. I think in fairness to Mr.
Well, Lord, I'm going to take you to His Honour Judge Rayside's decisions in relation to that. All of these matters were in evidence before the court. I'm not showing the court any, except for the authority of Ms. Ambrose, as it were. I'm not going to take the court to any document that wasn't before the learned judge. All of these materials were there. The case has developed a little bit, it has to be said. As pleaded, it was a claim for damages. And it has become now a claim for reconstitution of the account. And so to some extent, as it were, that as the case that we have to neat shift, so that the submissions we make in relation to it also shift to some extent, because we're meeting points that were raised on appeal for the first time. But if I may, I'll deal with that when I come to that specific part of my submission.
Certainly, but it will have to be dealt with.
Of course, my lord, of course. I'm acutely conscious of this matter, but as I say, I will deal with it at that point if I may. This is just background, as it were, and I'm trying just to set the scene for my legal submissions when I come on to them. As I say, both His Honour Judge Rayside and Mr. Justice Smith held that Moorwand had received a conforming instruction and were obligated to pay. I can show the court that at the appropriate moment. Now, there's a point in the background against me that I have to confront. It's an elephant in the room. And again, the easiest thing may be to me to summarise it, as it were. When Moorwand accepted R&D as a customer, the Money Laundering Regulations 2007, which were the regulations in force until the 26th of June 2017, required Moorwand to apply customer due diligence measures in order to prevent the account from being used for money laundering and terrorist financing. It is common ground for the purposes of these proceedings that what Moorwand in fact did failed to comply with its obligations under those regulations. Can I deal with this in two parts? First of all, the nature of the duty, and secondly, our failure to comply. The regulations aren't in the bundle of authorities, but can I invite the court to take out the authorities bundle behind tab 17? It's the case of P&P Property against Owen White and Catlin, LLP.
Did you say 17?
Tab 17, 1 7, my lord. Behind page 537.
Not sure. I'll see what is behind 537. Halfway through Philip.
Ah,
I've got P&P at tab 15 at page 399.
my lord, on our side we unfortunately filed a alphabetical bundle, which failed, of course, to comply with the requirements. So we filed.
Well, I just want to make sure. I mean, I don't mind.
Lord,
I just want to make sure that I'm following what you're trying to say, even if it's in an entirely different place. So we'll have to find a way of working on that. But now that you're both alert to this, it sounds as if my lords are in a happy place, and it being where it's meant to be.
I'm using the chronological bundles, which have the same reference as Council does.
Right. Okay. Well, then you can help me as you go along.
if I may, my lord.
All right. So we're anyhow for the moment we're in P&P.
We're in P&P.
But you may have to give me some signposts within the case because it won't be page numbers for me.
No,
because I'm afraid I can't
I'll give
do.
your lordship the paragraph numbers, and the paragraph number on which I begin is paragraph 29.
Right, this is Lord Justice Patton.
It is indeed. It's Lord Justice Patton at 29.
Thank you. I've got it.
And if your lordship could read through as far as the end of paragraph 31,
Thank you.
you'll get the flavour of the duty that with which we failed to comply.
I'm sorry, what was the paragraph number?
Paragraphs 29 to 31, my lordship. On pages 556 and 557 of the chronological bundle.
Yes.
Lords, we particularly rely upon the passage starting at letter D, saying that the regulations do not and are not intended to create a statutory liability to victims of fraud. Although they may have deterred or prevented the frauds, that's not the purpose. And any civil liability must therefore be established under the general law rather than under the regulations. And just going on to, if I may, paragraph 78 in the judgment of Lord Justice Patton. Can I, having shown the court what the duty was, can I show the court now what His Honour Judge Rayside decided about our failures in relation to it? And that's in the core bundle behind tab 17.
Question that occurs to me, I'm sorry, tab 17, the question that occurs to me, you say that these were the MLRs that were in force at the relevant time in these proceedings. Have, they've been superseded, have they?
Well, they were superseded as from July 2017, as I think I said to your Lordship, by later money laundering regulations. Did I say July? I'm sorry, it was the 26th of June 2017.
Right, so we're now in what bundle?
We're
In Judge Rayside.
Judge Rayside, the
Yes.
core bundle.
Thank you. Paragraph?
Paragraphs 62 to 66, if I may. And it's page 204 and 205. And again, perhaps I can just invite the court to read those passages to itself. shortly, there were queries about two of the documents provided by R&D, which were intended to prove the company's address. An invoice from a company called Unicom and a utility bill. One of the people at Moorwand dealing with these documents noticed that there were problems with them, but for reasons which are unexplained, owing to the passage of time and the change of ownership and personnel at Moorwand, the queries about them do not seem to have been followed up, yet the account was opened. May I now return to the chronology and to the fraud perpetrated on Mr. and Mrs. Hamblin. In early April 2017, Mr. Hamblin began engaging with someone calling himself Paul Kingsley, who we submit was probably X, on behalf of what Mr. Kingsley represented was an entity called CEX Markets. Mr. Hamblin was enticed by Mr. Kingsley to invest in the integrated automated trading system of CEX Markets by the promise of what, as I have mentioned, were objectively entirely unrealistic levels of probable return on his investments. Mr. Kingsley provided Mr. and Mrs. Hamblin with an account number for CEX Markets, and they made a test payment of £5,000 on about 7th April 2017. In May 2017, Mr. and Mrs. Hamblin discussed with Mr. Kingsley making a further investment of £140,000. However, the bank details for the transfer of the £140,000 that they were given this time were entirely different to those which they'd used for the test payments. The account details they were given were those of Moorwand's account at a bank in Denmark. As Hamblin looked up Moorwand, and as His Honour Judge Rayside records in paragraph 85 of his judgment, was somewhat concerned to read that it seemed to be a UK company which has a high-risk rating with very limited resources and seems to have had a rapid succession of directors. This is some cause for concern. Mr. Kingsley, however, managed to reassure the Hamblins, and on about 12th July, they transferred the £160,000, which is the subject matter of this claim, to Moorwand, the account of R&D. This is all recorded in the judgment of His Honour Judge Rayside at paragraph 74 to 96, and I'm just summarising it so that the court is aware of where we get to. The £160,000 which Mr. and Mrs. Hamblin transferred was credited as £159,992.81 to the sterling account of R&D with Moorwand. Thereafter, by 27th July, that amount had been withdrawn, mainly for the purchase of Bitcoin, but also in 3 sterling transactions. These are all set out in the judgment of His Honour Judge Rayside at paragraphs 101 to 106, but they're not actually put together in a table in chronological order there, so I wonder if it might help the court if I just listed them for the court's note. On the 18th of July, £9,760.08 we used to buy Bitcoin. That same date, £150 sterling was paid to something called Frank Designs, with a Z at the end of it. Also on the 18th of July, £40,000 was paid to something called Global Self-Drive. Also on the 18th of July, £34,500 were paid to something calling itself Authentic Luxury Watches Trading. Then on 19th July, £9,222.93 we used to buy Bitcoin. On 25th July, £55,285.17 we used to buy Bitcoin. And on the 27th of July, £20,000 £20,269.18 were used to buy Bitcoin. Those 7 withdrawals, making a total of £169,207.36, which, as His Honour Judge Rayside held, exhausted the £160,000 which had been transferred. And those are the challenged transactions, if you like, which it is said that we should have prevented had we been complying with what is said to be our quince care duty. The computer-generated records for these payments are in the supplemental bundle, and I will invite the Court's attention specifically to them when I deal with the practicalities in the 4th section of my submission. Mr. and Mrs. Hamblin carried on making payments to CEX Market. They paid them a further £50,000 on the 16th of November 2017 and a further £90,000 on the 11th of January 2018. But those payments were made through something called World First rather than Moorwand, and so do not form part of the present claim. RND was struck off for failing to file returns on the 31st of July 2018. In January 2019, Mr. and Mrs. Hamblin applied for a Norwich Pharmaca order against Moorwand and World First. In August 2019, they applied to restore RND to the register, and that was ordered on the 21st of November 2019. And these proceedings were begun on 15th February 2022. His Honour Judge Rayside heard the trial from 15th to 17th April 2024 and handed down his judgment on the 23rd of April 2024. The appeal before Mr. Justice Marcus Smith was heard on 17th and 18th March 2025, and Mr. Justice Smith handed down his judgment on the 4th April 2025. And, as I say, adjourned consequential matters, including interest. All that, my lords, is the background. And against that background, I now turn to the first of the substantive headings under which I'm going to be making my submissions, which is who in law was the sole shareholder and director of RND, which is grounds 2 and 3 of our grounds of appeal, and is dealt with in paragraphs 26 to 32 and 33 to 37 of our skeleton argument. And I hope the Court will allow me this indulgence, that if I do not refer to every point made in our skeleton argument, I'm not abandoning the point, I'm merely trying to keep myself in the time allowed. Both His Honour Judge Rayside and Mr. Justice Marcus Smith approached the case on the basis that the real Mr. Stanfield was the sole director and shareholder of RND. If I can invite the Court's attention to the core bundle behind tab 17, the judgment of His Honour Judge Rayside. One can see in paragraph 57 of his judgment the relationship between RND and John Stanfield, whose name was borrowed as part of the fraud, is perfectly straightforward. He is the only director of the company and the only shareholder. If we turn back to tab 11, which is the judgment of Mr. Justice Marcus Smith, one can see tab in paragraph 24b of his judgment. The person authorised to act for RND was a Mr. Stanfield, a real person who was himself the victim of identity fraud. There was a good deal of material to suggest that the person in fact purporting to act for RND was not Mr. Stanfield. The judge failed to weight these factors by treating the agent acting or purporting to act for RND as indivisible from RND. Thus, the judge treated all acts by the unknown fraudster masquerading by Mr. Stanfield as those of RND. Again, for the reasons I've given, this was an error of law. In our submission,
Could you just say something about the second sentence of B? The person authorised to act for R&D was a real person.
yes.
Authorised by whom?
Well, that's a very good question, my lord. When we come to the question of what R&D was, which I'm about to move on to, one gets to this difficulty that although a company is a legal entity, a concept, as it were, and has, as so often been said, no ding and sick, whatever, there's no entity and no physical matter. It can only do things by human beings. And the question is, who does the law regard as authorised to act? It's not so much, it is sometimes a question of some organs of the company conferring authority on others. It is some questions of the law deeming certain organs of the company to have authority.
Is it to be read as the person authorised by law to do so? And if so, is that a correct statement?
No. And I'm going to develop that, if I may.
I mean, one of the oddities here is the case is conducted on the basis that someone was able to commit R&D to a contract, and at least per Mr. Justice Marcus Smith to authorise the real Mr. Stansfield to act on its behalf.
Well, this is the curiosity, my lords. Again, if I can just divert a little bit. Philip establishes that the Quinscare duty is an implied term of the contract between banker and customer, part of their relationship. That means there must have been a relationship created between whatever this entity, the company is, and Moorwand, in order for there to be a company, for there to be an implied term which we can then have broken. But if Mr. Stanfield didn't do it, then there wasn't any contract.
But this case has not been conducted at any point on the basis of no contract, which would raise a number of interesting but different issues. To
Absolutely, I'm not putting my case on that basis. I'm just exploring, as it were, the theoretical possibilities. Yeah. If I can come back to the law, in our submission, the decision of Mr. Justice Smith that Mr. Stanfield, the real Mr. Stanfield, became both a director and a shareholder in R&D was simply wrong as a matter of law, having regard to the undisputed fact that Mr. Stanfield knew nothing about and did not give his consent to the formation of R&D with him named as a member and director.
Why do you say it's merely wrong as a matter of law? Is it wrong as a matter of fact?
Yes. But I'm not seeking to go behind a factual finding. I'm saying that on the primary facts as found by His Honour Judge Rayside, which were that the name of Mr. Stanfield was used, but that he knew nothing about it. That in law means that he was not the director or shareholder. In our submission, you cannot become either a member or a director of a company unless you agree to do so. You cannot be forced to take up these roles.
But I'm sorry, maybe irrelevant, but I'm just obviously not as familiar as the rest of you are with this situation. But it strikes me as very odd to say of somebody who knows nothing about anything that they are in fact a director of a company.
Well, indeed.
I mean, how can that be?
We say it's plainly wrong.
Yes, but it's not a matter of law, this.
Well,
it's a matter of, I mean, just as a starting position,
yes.
As a matter of fact, it surely can't be the case, as you've said, that you can become an officer of a company without ever having heard of it.
Well, that is the nub of our submission.
In the same way as if somebody bought a house in my name or sold a house in my name, it can't. If I know nothing about it and have nothing whatever to do with it, I've just had my name pinched. I can't be the owner of the house.
Well, that is our submission. Sadly, in English company law, it's not quite as straightforward as that.
No doubt.
Because of the provisions for deeming and things like that appear in the Companies Act. But
Right, but that's not what we're concerned with here. We're not concerned. Are we concerned here with a deeming provision, namely that somebody whose name identity has been stolen is deemed to actually be the member of the company?
There is no such provision, my lord. But your lordship has encapsulated this ground of appeal, that Mr. Justice Smith got it wrong, as it were, by saying that it was the real Mr. Stanfield. And it's relevant on the facts of this case, because what was pleaded against us was that these payments were unauthorised because they were not authorised by the real Mr. Stanfield.
I want to just test this proposition to this extent. At the moment, you've made submissions which I understand that you cannot be made an officer or a shareholder of an entity without your consent, and as to whose existence you have no knowledge. I understand that submission. It is possible, isn't it, to authorise someone, to give someone actual authority to do something, even though they may be unaware at the time of conferring the instruction or subsequently that they had that authority.
My lord, unpick that a little bit. Undoubtedly, I could authorise my solicitor to write my name on the authorisation form, but that then becomes my act. The act of my agent within his authority is my act. There's no suggestion that Mr. Stanfield knew anything about it, much less that he gave authorisation for it. And there's no pleading that another way you could do it is to ratify what's been done. There's no pleading against us that he ratified it.
No, well, each of you are keener on the strict record in this case, depending upon different points of where we are. But I'm just questioning whether it is in fact the case that you cannot give someone actual authority without them knowing about it. I'm not at the moment persuaded that is necessarily correct.
Authority is as your lordship knows, in various bits. To give someone authority to do something in advance requires you actually to authorise an actual authority. You can give someone ostensible authority to do something by, of necessity, holding out to the third party that they have authority. And you may not realise that you are doing that. So it is, I'm just testing the theory here, whatever. It is possible that by something you have said or done to a third party, you have held out a stranger, somebody else, as having authority to act on your behalf, even though you actually don't realise that you've done that, because objectively you're looking at the matter as to how a reasonable person in the position of the other party to the contract would interpret what you've done.
So you say it's really ostensible authority.
It would be ostensible authority. But actual authority actually requires you to give the authority, and you need to give it in advance.
Yeah.
Then
you not only need to give it, but the agent, the putative agent, needs to accept it, doesn't it? It's a relationship.
It is.
And if I purport to give you authority, but you never get the letter, you don't become my agent.
No.
Because, or if you do get the letter and you say, oh, I don't want to be your agent, then again, you don't become my agent. Is that right?
My lord, indeed. Absolutely.
For actual authority, I mean, ostensible authority is really a completely, I mean, we treat it as if it's the same as actual authority, but it's really a completely different branch of the law. It's about the protection of third parties, not about the relationship between principal and agent.
Absolutely, my lord. It's about the holding out by the alleged principal to the third party. And then the unauthorized, by definition unauthorized, because you don't need to rely on ostensible authority to have actual authority, the unauthorized act of the person who's been held out as agent. None of that arises on the fact of this case. It's not a matter of the strict record, as it were. The reality is that the case was put, and the judge at first instance too, and in the court of the High Court, held that the real Mr. Stanfield was the person authorised to give instructions on behalf of the company because he was the sole shareholder and director, and that, I submit, was plainly wrong. Whether it was a mistake of fact or a mistake of law, or for my purposes, doesn't matter. It was simply wrong, or both. Your Lordship is probably right. It was probably both. But on the undisputed facts, as found by the judge at first instance and not challenged on appeal, he knew nothing about it, and in those circumstances, he can't get it. Can I just make that good, because there are some company law aspects of it. In the authorities bundle, behind tab 28, there's the judgment of Lord Justice Snowden in the case of Re JDJ Construction. Chronologically, alphabetically, this will probably be somewhere else. I apologise, but it is.
No, don't worry. I now have a chronological copy of the bundle. Courtesy of my Lord Justice Nugee. Which number are we at?
It's tab 28.
Thank you. Yes.
And the passage on which I rely starts at page 871 in paragraph 49. And can I invite the court to read down as far as paragraph 51?
Yes, but give us the bullet points before we do.
Very shortly, that's authority of the proposition that despite the various provisions of the Companies Act which say that the register is the usual position is that the register is conclusive evidence, is prima facie evidence of the what is stated. But we say that that does not apply where the person concerned didn't know about it. That it may be binding against somebody who's agreed to have their name on there, and it's binding even in circumstances in which you may have been induced by fraud to put your name on there, but it simply does not apply where...
Well, it's 38 to 49, a statement of the normal position.
Yes. 38 to 49 is a statement of what I just said to your Lordship, that despite the various provisions which say that the register is evidence of who the members and who the directors of the company are, it doesn't apply where you haven't given your consent. This case deals with members, but there's also a passage in Palmer's Company Law at 8503, which is behind tab 36, which says the same with regard to directors. I won't labour the point, because but it is a point of company law.
Yes.
When the Act says that the subscribers are deemed to have agreed to become members and shall be members, that means the person who's actually signed the memorandum, not the person whose name he uses?
Absolutely. It cannot mean, we submit sensibly, somebody who was not authorised the submission of the memorandum, who knows nothing about it. Some random stranger in the street can't make me a director of a company by putting my name on a form that they give to Companies House.
No.
Some random stranger cannot make me a shareholder. Shareholders, for example, can be liable as shareholders for unpaid calls and things like that. It's not an exclusive benefit, as it were. It can also be a burden. You can't impose that on someone just by putting their name on a form which they haven't authorised. And directors have duties not only under the Companies Act, sections 171 to 177, but also under the Insolvency Act and the like. You can't impose those obligations on them by putting their name on a form without their consent and sending it off to Companies House. The contrary, we submit, would be a reproach to the law. Well, that presents certain difficulties in the present case, because the real person, Mr. Stanfield, never authorised the setting up of this company. And
He didn't subscribe the memorandum.
no, he didn't subscribe to the memorandum. So, now, logically, but for the Companies Act, there would be two possible analyses. Either the company was never validly set up because no person subscribed their name to the memorandum, or that it was validly set up by the person or persons I have called X, albeit under a false name and a false address. Now, unfortunately for the simple answer, the first of these options is in the UK a statutory impossibility, because Section 15(1) of the Companies Act provides, when the documents have been filed at Companies House, for the registrar to issue a certificate of incorporation. And Section 15(4) provides that that certificate is conclusive evidence that the requirements of this Act as to registration have been complied with, and that the company is duly registered under the Act. And that is stated in Palmer's company law as meaning that under the law of the UK, the question whether the formation of a company is null and void cannot arise in view of the conclusiveness of the certificate of incorporation once it is issued. And I'm not going to try and say that that is wrong.
In any event, it wouldn't help the claimants, because if the company didn't exist, it doesn't have a cause of action.
Well, it would help me a great deal, because if the company didn't exist, that would be the end of the case.
Yes.
But sadly, I cannot argue for that in view of Section 15(4), which says that the company exists if it has a certificate of incorporation, even if it's actually been signed by someone who's not the person that named and appears there. And that means, we say, that the only logical alternative is that the true sole shareholder and director of RND was at all material times X, the man who filed the documents of Companies Registry, and the man who signed the, I'm saying man, no, X, the person who signed the agreement with Moorwand. That, we say, has fatal consequences for an action brought effectively by RND against Moorwand, because it means that X was at all material times the sole directing mind and will of RND. It also means that Mr. Justice Marcus Smith saying that His Honour Judge Rayside was wrong to treat the acts of the fraudster as being the acts of RND on a false basis.
And is it your submission that if you're right about this was the entry point for Mr. Justice Marcus Smith to say he was entitled to revisit the evaluative fact-finding decisions of His Honour Judge Rayside, and if you take that away, then the deference to those assessments that one normally gives comes back into play?
Precisely. That's exactly my point on this first ground of appeal. Now, that brings me to the second of my headings, is the extent of that sole shareholders and directors' authority to act on behalf of RND and the consequences for this case. I'm going to start with a couple of simpler and less conceptual issues, pleadings and warranties. The pleading point is dealt with in paragraphs 38 and 39 of our skeleton. Can I invite the court to look at the pleading against me? Behind tab 21 in the core bundle, starting at page 274, are the amended particulars of claim, settled by the learned friend Mr. Hillsmith and served on the 18th of May 2023. The amended particulars of claim begin at page 274. I'm sorry, I keep adjusting my glasses. I'm afraid I'm getting used to new ones. Don't always work in the way that I want them to work, so I've got 3 different pairs putting on at different times. I apologise, it means I have to stop for a moment. Can I invite the court just to run its eye over paragraphs 1 to 7, which simply assert that CEX Markets was all a fraudulent sham, and that in consequence money paid over for the purpose of investment in CEX Markets were impressed with the trust without the need for any rescission on the part of the claimants arising from the Alley exception to which my Lord Justice Nugee has already referred. Clause 8 of the particulars of claim in part is an answer to the question of whether the point I was making about electronic money or authority operations was a matter that was in issue beforehand, because it's pleaded there that Moorwand was a payment service provider and an electronic money institution regulated by the Financial Conduct Authority, and offering, among other services, an electronic wallet under the name UPay card. The electronic wallet recorded stored value and allow users to make electronic transactions therefrom. Paragraph 9 says that RND was under the control of the fraudsters and intended to be utilised by the fraudsters in the implementation of the fraudulent CEX market scheme. That echoes what I showed the court at the outset in the reply. Moving on to paragraph 15, Mr. and Mrs. Hamblin here say that Mr. Stanfield was a real person who had no knowledge. The fraudsters used his name and his documentation to open the account without his knowledge or consent. And paragraph 18 says in terms that the only person authorised to give instructions for the transfer of money out of the digital wallet was Mr. Stanfield, the real person. And it says it not once but twice. I'm going to read the entirety of this, if you'll forgive me. Paragraph 19 pleads the quince care duty not to execute a payment instructions in circumstances when Moorwand was put in inquiry that payments were not duly authorised by RND. Paragraphs 20 to 26 plead Moorwand's failure to comply with the money laundering regulations. And paragraph 26A deals with the Unicom invoice. And paragraph 27, in consequence, says, in the premises, the account should not have been opened and or operated, and the monies received into the account should have been returned to the claimants without any transfers being made out of the account. paragraphs 29 to 31 plead the payment into the account and the payments out. And then paragraph 32 says these payments out of the account were all unauthorised by the second defendant, by RND, in that Mr. Stanfield did not authorise any of these payments and the first defendant should not have made them. So, again, we shouldn't have done it because the real Mr. Stanfield didn't authorise, but the real Mr. Stanfield wasn't the director, wasn't the person who gave us the authority. Paragraph 34 says that had Moorwand undertaken ongoing scrutiny, it would have realised that the account was not being used for the purposes of any legitimate business activity, but rather was being used in a manner not properly authorised by RND and or for the purposes of money laundering. Our submission is that the reference in paragraph 34 to the payments not being properly authorised by RND has to be read in the context of the pleas in paragraphs 18 and 32. Only Mr. Stanfield was entitled to give instructions on RND's behalf. What it means, we say, is that the real Mr. Stanfield didn't authorise them. And paragraph 35 says, in the premises, having been put on inquiry that the payments were not authorised, properly authorised by the second defendant, by reference to the matters pleaded at paragraph 32 and 34 above, the first defendant was in breach of duty of the second defendant in making these payments.
I just would work out how this fits in. Obviously, there was a debate before Mr. Justice Marcus Smith as to whether this point was open on the appeal or not. The pleading point was taken by Ms. Knight before him. People on appeals do occasionally try and say that a point can be taken fairly for the first time on the appeal that was not taken before. And I think we all recognise we may have some arguments of that kind to come on your part in this appeal. The judge, having concluded that the point was there on the pleadings and could fairly be taken, what's the nature of your tasking seeking to challenge that finding, that procedural decision before us?
I start off by saying that Mr. Justice Marcus Smith began his consideration of all of these matters from the false premise that Mr. Stanfield was the true director and author of the matter. If Mr. Stanfield was the true author of the matter, then showing that Mr. Stanfield didn't authorise them made them unauthorised. If, on the other hand, Mr. Justice Marcus Smith approached the matter, as we say he plainly did, on the wrong basis, he was looking at the wrong issue.
The Bilter and Singularis cases and this complication, if I can put it that way, I think even Brinksmat were all in play by way of argument below, weren't they?
Indeed.
So.
Indeed. As I say, one comes back to the question of who is the law regards as having authority to give instructions on behalf of the company. But one gets here an entirely different factual situation. If you say that the real Mr. Stanfield was the only person authorised to give instructions, which is what is pleaded against us, and Mr. Justice Marcus Smith found was the case that the real Mr. Stanfield was the sole director, and you also have the finding of fact at first instance that Mr. Stanfield knew absolutely nothing about it, uncontested, you get the point that no one gave instructions to open the account, no one gave instructions for the payment who had any kind of authority, because the only person who had authority was the real Mr. Stanfield, who knew nothing about it. So one's looking at a factual situation in which on the uncontested facts, the only person who had authority to act on behalf of the company didn't do any of the things on which we rely as authorization.
I mean, obviously you weren't burdened with appearing below, but at least as I read the judgment with the reference to Hampshire land and look at the authorities cited, at the moment at least, it does seem to me that this point of attribution to a company, where the company is being used as an instrument of fraud, was in play. Now, if you're saying that it wasn't and or could not fairly be dealt with by the judge on the basis that you say, well, it's not pleaded and so on, and we can look at the pleadings, I think I'm going to need hear a little more about that.
Lord, we say that Mr. Justice Smith made a fundamental error in attributing that, and that infects all the rest. And he was wrong, we say, to decide against us, and this is a ground of appeal. He was wrong to decide against us, but it was open to him to deal with the matter of attribution, absent the pleading against us. She describes it as a minor pleading point. That's not the way the case was put. I mean, Lord, this is a second appeal. But even on a first appeal, the judge has to look at the pleadings and get it right, as it were. And we say if it's plain on the face of the pleadings that the case being put against us is not made out on the facts, then that ought to have been the end of the appeal. But it wasn't. And we say that was a mistake which this court can rectify, because it involves the learned judge not merely failing to pay respect to the views of the first instance judge, but as it were himself taking it upon himself to decide the case on a basis which has not been pleaded.
This is going back a little bit, but you said of paragraph 34 that the allegation that it wasn't properly authorised by R&D was to be read as brackets because only Mr. Stanfield could give instructions and he didn't give instructions. But it doesn't there say that.
Does it?
What it particularises are the nature of the purchases as being quite alien from any legitimate business activity. That seems to be a different point.
My lord, it is.
Because if the point had simply been they weren't authorised because Mr. Stanfield didn't authorise them, you wouldn't need to set out that it was used to buy luxury watches and Bitcoin and so on and so forth, because the lack of authority from Mr. Stanfield would have meant they weren't authorised whatever they were spent on. So I'm not sure I do read paragraph 34 as making the same point again. I read paragraph 34 as making a different point, which is the nature of the purchases was such as to show that the transactions were not authorised by anybody because they weren't legitimate activity. And that comes rather closer to the builder and so on point about attribution, doesn't it?
Lord, it does. If one reads it in that way, is it our suspicion that it is not to be read in that way in context?
Yes.
Don't forget the purpose of the pleading is to make clear to us the case that we have to meet.
Yes.
The case
I'm
the
very
case
well aware of
expressed-
that. Yeah.
It's expressed in a number of alternative ways, isn't it? I mean, this is, it's a further and alternatively paragraph that you're dealing with at 34.
I mean, Mr. Hillsmith's skeleton argument before his Honour Judge Rayside pleads, paragraph 106, Lord Legate in Barclays Bank, it would be possible in theory for a principal appointing an agent to agree the agent may bind the principal even when the agent is acting dishonestly with the aim of defrauding the principal. But it seems inconceivable that any sane person would ever agree or could reasonably presumed to have agreed to confer such an authority on an agent. Now, there are many other paragraphs which would lead me to believe that the Bilter and Singularis points were firmly in play before his Honour Judge Rayside. Now, freed from, as I say, the burden of having been there, you're able to make this submission to us. But at the moment, at least, I would want to know a great deal more about why you say no one should properly have understood that this point was in play.
I don't think I say that they shouldn't have understood that it was in play. I was saying that on the basis of the pleadings, the point is that you start off with the fact that the real Mr. Stanfield is the only person authorised. And that said not once but twice gives a flavour of to everything that comes afterwards, and that we, reasonably reading these things, would see them as being an aspect of that. Now, in addition, there were a whole series of points that were argued at first instance. I'm sure there were points in our skeleton too about them. My learned friend, Ms. Knight, was well up on the authorities from Brinks Mat onwards as to the possibility that even in a one-person company.
Well, she specifically argues exactly the point in her reply, Sky, fairness to her, that Singularis is different because the company there wasn't solely and exclusively a vehicle of fraud. I think we can all see as a central point in this part of
Yes.
this case. So it's argued before the first instance judge, isn't it? His Honour Judge Race.
Lord, it is. But the fact is that although it may be argued, but it doesn't mean that it's open on the pleadings. And Lord, it's a short point. If your lordships are against me, I can't improve it by repeating it. But we say that all of this, the repeated assertions that the only person who was authorised to give authority was the real Mr. Stanfield, which finds its way into His Honour Judge Rayside's judgment, and finds its way into Mr. Justice Marcus Smith's judgment, is a fundamental problem with the whole of the case. Because one's then looking at the activities of X and at the nature of the company. And the point made, as the Lord mentions by reference to Brinks Mat, Bilter, Singularis and the rest, all of which are plainly distinguishable on the facts because none of those involved a company, with the possible exception of Brinks Mat.
I was going to say, Brinks Mat was a fraudulent company. Scanlon was set up for the purpose of laundering the money.
Your Lordship is right. But of course, that's a comment made on an application for permission to amend rather than after a trial.
Yes, comment may be slightly downplaying the firmness with which Lord Justice must still expresses himself. But we can look at that in due course.
The Lord, yes, but it is a comment made, as I say, on an application for permission to amend.
Yes.
So anyway, there's the pleading point, and then
an obiter ratio point, perhaps.
Well, it says it's arguable, because that's the ratio of a grant of permission to amend. It is at the least arguable. I think that's the phrase. It is at the least properly arguable.
I think he said strongly arguable. But we can, as I say, we can look at it in due course. But I was just picking up, because I think Scanlon, the company used by the Brinks Mat robbers, was set up for the very purpose
Indeed.
of perpetuating the theft.
Indeed, my lord. It is the nearest analogy to.
Yes.
I think Bilter Limited and Emtic fraud companies are almost, but the difference there was the claim wasn't against an innocent third party, was it? It was against the fraudsters themselves.
It was against the fraudsters themselves, and it's very clear that it would make no sense when trying to claim against a fraudster to attribute to the person making the claim.
It's a much easier case.
It's a much easier case. And Singularis and Daiwa is a case which involved not merely the payment service provider, but the investment bank, lenders, the advisors. They knew all about the accounts. They knew what Mr. Alsania was doing.
Well, it was innocent money in fraudulent application of it, wasn't it?
Yes.
So,
But it was a very different situation to that of us. As my Lord Justice Nugee says, the nearest thing is scandal, which was set up for the purposes of laundering the Briggs Mat fraud. I had the pleasure of being involved in some of the peripheral cases to that. And the day I took silk, I took my wife into a court which was full of people with submachine guns to make my bow before the judge who was hearing the Briggs Mat case. And my wife said, "I thought, Richard, you didn't do any crime." But so I remember that well. But as I say, in relation to that, it is not of itself a ratio decidendi point against us, that where the nature of the fraud is. You don't get, it is not possible to say that a company set up for fraud can't, as it were, turn round on you and say you ought to have prevented the very thing which I was set up.
So just the principle you are contending for is a principle of law that where a company is set up for the dishonest purpose that is said to be the fraud on the company, and the claim is not against the fraudsters but against a third party, the acts of the fraudsters in carrying out the fraud are attributable to the company. That's the proposition of law.
The Lord, yes. Okay. Exactly. And that brings me very neatly to the point I was making, which Lordship may not like, but I intend still to make it on the authorities, the warranties rather, the terms of the business account agreement. Because, again, one comes to this point, who has the authority to enter into contracts? There must be a contract, otherwise there can't be a claim for breach of an implied term of that contract. There's nothing, we say, intrinsically wrong in entering into a contract for the provision of payment services. Nothing intrinsically wrong about that. It's the kind of thing which, if X has any authority, he must have authority to do. And we say that within that, he then has authority to give the warranties, which are in our terms and conditions. This is dealt with in paragraphs 40 to 43 of our skeleton argument. We say that it was plainly within X's actual and ostensible authority to do this. The warranties are in tab 11. They're also set out in paragraph 21 of our re-amended defences. Now, when the company rocks up to say, you should have stopped us, we say, well, but the contract which you are saying has an implied term that we ought to stop you contains a warranty from you that you're behaving lawfully.
Well, I mean, when you say, I think the reference was aiming to be, didn't like the point. I absolutely understand the point, and it's fair to say that the rules of attribution of fraud of directors to companies favour attribution when a claim is brought by a third party against the company for the fraud. It's more the question of this point arising for the first time in this court on a second appeal. That was my concern, as a procedural one.
Well, my Lord, the point of estoppel and equal and opposite claim wasn't made below, but before His Honour Judge Rayside, these terms were undoubtedly in play. They're plainly pleaded. They were referred to in His Honour Judge Rayside's judgment.
Is there not?
Are they not?
No.
Clause 16 is. I'm not sure we have the.
I think there's a reference to there are some perfectly standard terms and conditions, but it's not necessary to set them out or something
No,
like that.
he doesn't set them up, but he refers to them. So he's
Can we look at what reliance was placed on in your pleading?
My Lord, yes. I mean, we plead them, but we don't draw any conclusions from them.
It's an immaterial averment, is it? I mean, the point of pleading facts is usually to set up some legal case, but people often plead facts which don't go anywhere. Is that the case here?
We say not, my lord, because
Well, can we look at how they're pleaded in your
yeah, absolutely.
defence?
My lord, it's behind tab 20.
Thank you.
And it's at page 252 to 253.
Thank you.
And it's answering the pleas in paragraphs 13 to 16, which are on pages 277 to 278. The fraudsters completed the UPay card agreement. The application purported to be submitted by the sole director whose name was given as Mr. Stanfield. 15. Mr. Stanfield was a real person who lived at this address, who had no knowledge of the application. The fraudsters used his name and his documentation in opening the account without his knowledge or consent. This is, of course, in the plea, part of the plea, as you will see, that paragraph 18, the only person authorised to give instructions was Mr. Stanfield. So it's in that context. And we get in paragraph 19, R&D's application to open the account purported to be submitted by Mr. Stanfield.
I think it's clause 39 on 263, which is probably the highlight from your perspective.
Yes. Yes, my lord. But what I was trying to show you, Lordship, was that actually these are answering, in their context, pleas that the real Mr. Stanfield wasn't entitled to, didn't open the account, and that the person who opened the account did not. And what we say back is, you warranted in the account that
But everything was accurate.
everything was accurate. So you, the company, either didn't open an account with us, in which case there's no contract, or you, the company did, and you opened it on these terms. And the reference in paragraph 39, to which I was coming, is of course a reference to damages, rather than a refutation, as it were, or an estoppel, because that's the way the claim against us at this stage was pleaded. There was a claim under the Payment Services Regulation for the money, but the gravamen of the plea, and I make no criticism of this because it was no doubt pleaded at a point before Philip had been decided. The gravamen of the plea was that it sounded in damages. After all,
It's a breach of duty of care. You would expect it to sound in damages.
precisely.
But Philip tells us that's wrong. What it actually does is it destroys the authority.
Precisely.
Yeah.
But one always has, forgive me for stating the obvious, but when one's looking at these things, one has to look at how it's responding, which is why I started with what was, as it were, said against us, as it were. So it's there on the pleadings.
I was trying to find whether that paragraph is carried into the skeleton argument before he's on a Judge Ray side. I couldn't find it.
That I can't assist your lordship with, but
it's not mentioned, and Your Lordship, I might mention that paragraph 25 as a reply to paragraph 9, divided 1 of the supplementary.
On page 9. My Lord, as I think I've intimated to your Lordships at the beginning of my submissions, it's fair for Mr. Hillsmith to take pleading points against me. And he can no doubt say, well, if I can take a pleading point in relation to the real Mr. Stanfield and things, so can he. But we say there is a difference between our pleading point and his. The pleading of want of authority to which I invited the court's attention involved the pleading of facts. The payment or instructions were unauthorised because they were not authorised by Mr. Stanfield. And it was an integral part of the claim of pleaded against Moorfield, Moorwand, that it was not entitled to carry out these transactions because Mr. Stanfield was the only person authorised to give instructions for them. And he not authorising the fact. The premise of that pleading is wrong because he wasn't the person authorised to give instructions. The basis of the claim that the payments were unauthorised because Mr. Stanfield has not authorised them falls away. By contrast, in paragraph 21 of our re-amended defence and in paragraph 39 drawing the consequences, we plead the facts and we plead that the claim, as it were, involves allegations that what is said in those terms was not true. As we say that the loss which they say was caused by what we did was caused or contributed to by the fact that those terms were not implied, because it's necessarily implied in the claim against us. First of all, that what was said in the account opening documentation was not true. And it is also necessarily implied in the claim against us that Moorwand had not, R&D had not conducted its business in a lawful manner. I say necessarily implied, it's actually expressly asserted. It's expressly asserted that these were suspicions of money laundering, that they were paying away for non-proper purposes and the like. You can't say that this was all set up to be a fraud and that, as it were, we had participated in the fraud by making payments when we shouldn't have made them, without implying that you're breaking the promise you've made to us as part of the arrangements between us for that you will conduct your business in a lawful manner.
But is the effect of this argument that the standard terms and conditions, those clauses would exclude or negate the effect of any quince care duty that might otherwise be owed?
Yes.
I'm just wondering, because you never know what might happen, but I mean, what if it had said, well, these are standard terms attempt to exclude that duty in these circumstances is not reasonable for the purpose of the Unfair Contract Terms Act, for example. None of that's been gone into.
What one comes back to Phillips. It's quite clear from that case, and I'll take the court to it in a moment, that Lord Leggett says that the extent of the duty is conditioned by the terms of the contract, whatever they are.
No, well, I mean, that it's contractual duty. That must be right. But I'm raising a sort of a separate point that as trying to work out would life have been different if this point had been developed at an earlier stage. One starts asking, well, what would have happened if it had been rather more to the fore, or what might have happened?
Well, Lord, again, it's been, one of the problems with this case is that it's been run on a false basis from the start. Because it has been run before the first instance judge and before Mr. Justice Marcus Smith, on the basis that the real Mr. Stanfield had anything to do with it. He was just another bystander, as it were. His Honour Judge Rayfield, however, treated the acts of X, even though he said he was the truth, treated the acts of X as effectively being the acts of the company, in the sense he was the person authorised to give instructions for it. And on that basis said, yes, what we did was fine. We may have been in breach of our duty under the PSR or the Proceeds of Crime Act, whatever else, the opening of the account. But it doesn't lie in the mouth of the company, this after all being a claim by RND, to say you shouldn't have opened the account with us. Because that destroys the basis of the claim. And that thereafter, when you look at these things, they were all specifically authorised, and they were paid out automatically by computer. Everything happened in the ordinary course of events, and that there wasn't a duty to us to look at them and make further inquiries. We did what we should have done under the Payment Services Regulations. That's His Honour Judge Rayside's decision. In comes Mr. Justice Marcus Smith and says, no, you were entirely wrong to attribute X because the real Mr. Stanfield is the only person. So you shouldn't have done that. We say he was wrong to do that, and that was his reason for undoing Judge Rayside, and therefore he shouldn't actually have gone into that on the appeal. And if that had been the case, none of this would come up. I'm now in the situation in which on a second appeal I'm having to go into these additional matters because of that error by Mr. Justice Marcus Smith. If Mr. Justice Marcus Smith had simply said, I can't interfere with the evaluative decision of His Honour Judge Rayside, we wouldn't be here.
But you, as I understand it, you assert that both judges were wrong to treat the real Mr. Stanfield as having anything to do with the case.
My Lord, yes.
But that error led the first judge into no wrong conclusion. But the same error led the second judge into a wrong conclusion.
Exactly. It led the first judge. The first judge treated what in fact happened as being authorised.
Right, because the first judge addressed what you might describe as the reality of the situation, whereas the second judge
looked at the theory and got the theory wrong. And that is why I am now addressing these slightly conceptual and more difficult matters, because I'm facing a point in which we say, His Honour Mr. Justice Marcus Smith got the theory wrong, stepped in, made his own evaluation on matters entirely different. And there are answers to those which I am giving to the court. But the straightforward one is simply that His Honour Judge Rayside got it right because that reflected the practicalities.
I mean, that's the risk I understand. What I don't understand at the moment is why these weren't all points capable of being in play before you knew what Judge Rayfield's answer was going to be.
My lord, I'm in some difficulty. I wasn't there, but I've no doubt Ms. Knight will inform me over the short adjournment. But if I may, I will carry on with this. As I say, as a pleading point, we do plead the facts. The facts are all there in play, and it doesn't actually involve any further inquiry on the facts, because the case against us is that illegality. That's an integral part of the case of R&D against us. And it's plain on the face of the warranties that if that be right, which we don't admit, but if that be right, if that case against us is right, then there's a breach of the terms to which R&D had agreed. So very shortly we say it doesn't lie in their mouth to come and make this case saying you owed us a duty to prevent the very fraud for which we were set up and which we warranted we were not going to commit. Finally, I come to the nature of R&D. And I'm going in this to spend a little time talking about who is the company for these purposes. In this action, Moorwand is in reality being sued by R&D, and there are times when Mr. Justice Market Smith fails to put out of his mind the fact that it's not Mr. and Mrs. Hamblin who are seeking to recover the money, for making payments which were actually authorised by the sole shareholder and director of R&D, X, yet are said to be unauthorised in the sense of not being within X's actual authority, nor within his ostensible authority. It's not pleaded against us that X was insolvent, either at the time or because of the challenge payments. Not a pleaded allegation. Or that it pleaded that Moorwand had any reason to believe that it was. So far as Moorwand was concerned, R&D was a solvent company which had warranted that its business was going to be conducted lawfully and that all that had been said to it was true, with a sole shareholder and a sole director. And that director could therefore do anything which the company could lawfully do. I put in lawfully because company directors can't do unlawful things. It's not within their actual authority in the sense of... but they can do, if they are the sole member of the company, informally, anything which the company can lawfully do. So I'm not, by these submissions, inviting the court to ignore the separate legal personality of the company, or to go behind the principle, for example, in Bilter at paragraph 184, that a sole director, who's also the sole shareholder of the company, owes that company the general duties set out in sections 171 to 177 of the Companies Act 2006. But the fact that a financial institution's customer is a company with a sole shareholder and director, and that that person is the only person who deals with a financial institution and operates the company's account, is, we submit, a very relevant circumstance in considering the likelihood of that person misappropriating his own company's funds in circumstances in which there is no evidence of insolvency.
Is the point we're on here whether the Moorwand was on notice? Is that the point that's being addressed at the moment?
Well, I'm going to come on to notice, as it were, in the second point. Here I'm just talking about the nature of R&D.
Right.
And that
Are you under your third or your fourth heading?
I'm still under my third.
Yes, I thought so.
I'm dealing with the nature of Moorwand, as it were. In that context, I've dealt with the extent of the authority of the sole shareholder and director.
Did you say the nature of R&D?
And in that context, I was sorry.
Yeah.
R&D.
Yeah.
I'm sorry. I've been on my feet for 2.5 hours, and it's a hot day. I'm afraid. I'm getting my.
At the risk of blowing you off course still further, if you said that the sole shareholder could do anything that the company could lawfully do.
Yes.
But the true facts, as now known to us, is that the 160,000 was trust money, and the only thing the company could lawfully do with it was give it back to Mr. and Mrs. Hamblin.
Quite right.
So the sole shareholder cannot give it away to anybody else or take it for himself or do anything. It's in that sense that he doesn't have authority to do something which is a perpetuation of the fraud on Mr. Hamlin. So once you've accepted the limitation that the shareholder's ability to deal with the company's money is limited to what the company could lawfully do, you effectively accept that X had no authority.
No actual authority,
So,
my lord.
yes.
The question is what it would have looked like to us as to the extent of his authority.
Well, I understand that, but that's a different point. That's the ostensible authority point.
Precisely. But your lordship is right. That's why I put the qualification, which is well known to the geomatic principle, that you can't use geomatic and informality to do anything that the company can't.
Just because you're the sole owner of the company doesn't mean you can steal the company's money and put it in your own pocket.
Absolutely. But the probability of a sole owner stealing the company's money to line his own pockets depends on all the circumstances.
Yes, I understand that, but that goes to whether you should have been on notice, which I understood to be the next part of your submissions rather than this part of your submissions.
My lord, that's entirely right, but this, as it were, was a bridge to that.
But I don't want to rush past this point too quickly, because Lord Legate does not say it is impossible in law for actual authority to be conferred to do an unlawful act. He just says
it's very improbable.
Which sane company would do it.
Your lordship is right.
And whether he had in mind companies conceived for the purpose of executing the fraud.
Well, it's interesting. The Companies Act says in terms you can't set up a company for an illegal purpose.
Yes.
So you cannot, in your company's constitution, provide for an illegal purpose.
But the remedy for that is an action by the Attorney General to have you taken off the register, because, as you said earlier, once you're incorporated, you're conclusively deemed to be incorporated. So the company has been set up.
My Lord, absolutely. I'm sorry,
I think there was a case where someone tried to set up a company to provide services of prostitution. Is that not right?
Yes.
And was duly taken off the register.
Yes. Your lordship is right. That
Miss Cynthia Payne.
Yes.
May have been.
The company exists. Section 15.4 says the company exists. You can't incorporate it for an unlawful purpose. That's and therefore, strictly speaking, the registrar ought not to permit it to be registered.
Well, if you say on the face of the memorandum, our purpose is to commit bank robbery, the registrar doubtless wouldn't incorporate you.
Absolutely,
I'm sure that the memorandum and articles here didn't say the purpose of the company is to defraud innocent victims.
Absolutely.
So it did get. So where does the point that the Companies Act says you can't set up a company for illegal objects, where does it take you? Because this company was set up, its objects were, in fact, to commit fraud, but that doesn't stop it from having been duly incorporated and having an existence.
Well, Lord, in my submissions, it doesn't take me anywhere. I was merely...
Right. Sorry. Well, in that case, it's my fault for leading you down
I was
a
sorry.
byway.
I was merely trying to answer your
Yes.
lordship's point. I mean, to complete the point, you can't set up a company for an illegal purpose stated in its constitution. You can, however, set it up to do something illegal without stating that in its constitution. If it is authorised, query whether actually the thing has been authorised. I mean, for example, insurance companies could possibly, in the old days, have entered into tunnel policies and things like that that were illegal at Lloyd's, but they were frequently entered into. And that kind of illegality would probably not be ultra vires the directors who authorised it. I don't know of no case in which anyone has come after the directors for entering into a policy like that. It might be that when one came to insolvency, if it came to insolvency, it would be a breach of directors' duties.
But I want to make sure I didn't misunderstand you earlier on, in that I thought you had accepted there could be no authority, no actual authority here on the part of X, assuming otherwise they are the person who is R&D's agent, to give instructions to move funds in breach of trust. That wasn't your case as I understood it when I read the skeleton, which is why I query it now, because I may well have misunderstood what you were saying.
You haven't misunderstood me, my lord. X is, as far as we are concerned, the sole person authorised to give instructions. X is the man who signs the contract. X is the man who gives the warranties. It is in that context that we look at X's authority from the company. And the question of whether he had actual authority is, we say, beside the point, because we are looking at it from the point of view of the fact that to the extent that the company has any existence apart from X, the only person who deals on behalf of X and therefore represents X to us, represents R&D to us, is X.
I mean, it's not beside the point if you don't succeed in your challenge to the judge's finding that a case of ostensible authority wasn't open to you, because on notice, you will notice in that scenario, it is the absolute key and central point, isn't it?
That, with respect, my lord, conflates two different things. The question of the quince care duty depends upon an implied term in the contract. The question of whether you know so that you cannot rely upon ostensible authority is a different question, which is not conditioned by the terms of the contract. That's an agency question. We are looking here at the question of whether we were in breach of a contractual duty to the company to comply with X's instructions. And as I'm going to say when I come down to the actual instructions, it was part of the company that we would work on the basis of whoever put the codes in. We gave the codes to X, we say we were entitled to give the codes to X, X did them, and the payments came out. That's what His Honour Judge Rayside found.
I was just looking to see, and I thought I'd find it in the unagreed supplementary bundle, the Memorandum of Association of R&D, but it doesn't in fact, although it's said to be at tab 11. Tab
Hasn't
11.
the memorandum been abolished, Your Lordship, I think?
Yes, it'll be the articles. The
Requirement for a memorandum
the memorandum is a one
Right.
page,
Well,
isn't it?
What I was looking for was a statement of what R&D was for, where that is to be found.
Well, Your Lordship, it's in the business account agreement, of course.
Yes, I know, but I was looking. I mean, when an application was made, then a whole lot of things, including a passport and a memorandum of association, were said to be attached to the application that was made to Moorwand, and I was looking to find the original of those documents. I'm sure you'll know where they are, and we can return to it after lunch. But if as is of course the case, there wasn't a statement that this is a single-purpose vehicle set up to defraud people, then what was said as to what the purpose of this organisation was? So can we return to find out where that was said at some point?
Would that be a convenient moment for all?
Yes, well, the clock never tells the right time, but it's as good a time as any to break. So we'll start again at 2 o'clock.
Authorizes